Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 18th of April 2025, Judge Stephen Hippler rendered a written order following a verbal proclamation from the bench on the defendant's motion in Limine number 14 concerning statistical analysis. And this particular ruling, it's very short, but it is quite compelling, because it states here and memorializes the fact that both sides, the state and the defense, agreed that an improper question was asked at the secret grand jury proceedings where the defense was not present, that occurred in May of 2023 and resulted in the return of the grand jury indictment, which charged Mr. Kohberger with 5 first-degree felonies, to which he is standing trial on. What does this order say? It says here, it's on page 6, defendant moves in limine to exclude any misleading comments about the meaning of a, quote, likelihood ratio, end of quote, for DNA purposes. Specifically, defendant seeks to avoid attempts to define likelihood ratio through a comparison to the world population. There's a footnote 6 here that says defendant's motion is directed toward the prosecutor's questioning of a lab analyst at the grand jury proceedings. There, the analyst testified that her DNA testing showed the profile developed from the sheath. This is, ladies and gentlemen, by the way, perhaps the biggest piece of evidence that Mr. Kohberger is facing trial on, the sheath that was found on the bed where 2 of the victims were at 1122 King Road. So again, there the analyst testified that her DNA testing showed the profile developed from the sheath was 5.37 octillion times more likely to be seen if defendant was the source than if an unrelated individual randomly selected from the general population is the source. In an attempt to clarify this result, the prosecutor asked whether this meant that, quote, if there were 1.37 octillion people, that it would be that Brian Kohberger is one out of that many octillion, end of quote. The lab analyst explained why this comparison is not a proper way to view a likelihood ratio. Let's return to the body of the order again. It continues, the state agrees that this type of comparison is inappropriate. The court grants defendant's motion insofar as it applies to the question asked by the prosecutor at the grand jury proceedings, which both sides agree was not proper. However, the court will not dictate how the question is to be asked at trial. If defendant believes that there is a similar misrepresentation as to the likelihood ratio at trial, he can object at that time. Now, ladies and gentlemen, bear in mind, there was supposed to have been a preliminary hearing that both parties had agreed to would occur the end of June 2023, that once this indictment was returned, it obviated the need for the preliminary hearing. It canceled basically the preliminary hearing. Mr. Kohberger was arraigned on the 5 charges returned by that grand jury indictment, and he is now standing trial for those very charges. The defense did attempt to set aside the grand jury indictment in an effort to, I believe, get the preliminary hearing back on track. Both of those efforts were denied. There were 2 grounds that were raised. One was prosecutorial misconduct. The other was inappropriate instructions to that jury before they deliberated. So it stands to be seen if on appeal, now that we have in the record the court documenting that this was an inappropriate question, that both sides agreed to it, and what, if any, impact it had on that indictment is unknown at this time. This will now conclude this episode of the Indie Zone podcast. My name is Kathy. Thank you for joining us here today.